Good morning, everyone. If I can please invite you to take your seats. We're about to start. It is such a delight to be back at this conference. It's been off to a great start, and I'm personally looking forward to this panel discussion. My name is Federica D'Alessandra. I'm Deputy Director of the Institute for Ethics, Law and Armed Conflict at the University of Oxford, and I will have the privilege to serve as your moderator today. I want to take this opportunity to thank the panel's organizers and conveners, as well as our brilliant speakers. Catherine Marshall, head of the International Impartial and Independent Mechanism to assist in the investigation and prosecution of persons responsible for the most serious crimes under international law committed in the Syrian Arab Republic since March 2011, or as we will refer to it today in its short form, the IIIM. Who's joining us online remotely from Geneva, as well as Mazen Darwish, a Syrian human rights lawyer and Secretary General of the International Federation of Human Rights, who's also joining us remotely. I'd also like to welcome Liz Evenson, Director of the International Justice Program, Human Rights Watch, who's joining us here in person, as well as Sam Zarifi, who's Executive Director of Physicians for Human Rights, and until recently, Secretary General of the International Commission of Jurists, with whom I've had the distinct pleasure of working on the idea of a standing UN investigative mechanism, which I think I'll raise as part of today's discussion. In this panel, we will discuss more broadly important developments and emerging ideas in the international criminal justice space. This is a field that is evolving at a record speed in just a matter of a few years due to the need to address crucial and persistent gaps in accountability. All the changes and developments that we will be speaking about today are prompted by ensure one common driver, motivating factor, which is victims' continued demands for accountability and a sense of agency that is so powerful, that is spurring so much innovation in a field that until recently many would have considered to be almost at a stalemate. From important developments at the International Criminal Court, which include, of course, but it's not limited to, the recently announced arrest warrant against Russian President Vladimir Putin, to a growth in universal jurisdiction cases in many countries, particularly in European jurisdictions, to the establishment or proposed establishment of new institutions, be they full-blown tribunals, like the tribunal that is being proposed for to try the crime of aggression against Ukraine, or investigative mechanism, like the proposal for a standing investigative mechanism at the UN. We're seeing a number of ways in which prospects for accountability are growing, and accountability is finding paths forward. Of course, if the field is evolving, the reason we're here to discuss persistent gaps in the architecture of the field, but also persistent challenges, such as the challenge of selectivity, why and how certain country situations are treated differently than others, and how do we overcome that, as well as, of course, the imperative to centering victims and their perspectives and in this common quest for justice. So I would like to invite our panelists to share some initial remarks and a few thoughts precisely on this question. How can we be sure that in the face of these developments and in the face of this innovation, we can continue to keep in mind the need to overcome and address challenges related to selectivity. And let me start maybe with Catherine Marshall, who will make some comments on the operational aspects and developments of the IIIM. And we will then go with Mazen Darwish. Catherine, the floor is all yours. Thanks for joining us.
Thank you, Alessandra. And I thank the organizers for inviting me to take part in this panel. Atrocities in Syria since March 2011 are devastating and barbaric. They deeply shock our conscience. The armed conflict is still ongoing in Syria. the absence of rule of law. All of this makes a situation in which every viable opportunity of justice arising in our accountability ecosystem must be seized, and it must be supported primarily for victims and survivors of these atrocities, irrespective of which community they belong to. In December 2016, when the General Assembly established the AAAM, such opportunities were scarce. Investigations concerning various perpetrator groups were conducted by a few national prosecutors operating outside of Syria, essentially in Europe, and their investigations were conducted on the basis of universal or jurisdiction or extended forms of extraterritorial jurisdiction. There had been already a limited number of convictions of low-level perpetrators associated mainly with non-governmental armed groups. A referral of the Syrian situation to the International Criminal Court was not in sight after the use of Russian and Chinese vetoes paralyzed the Security Council. However, the General Assembly decided that the overwhelming amount of documentation of the atrocities had to be centralized and had to be preserved, and that analytical work and case building following a criminal law methodology had to start, not only to support national courts that were already seized of the aspect of the Syrian situation, but also to support in the future regional or international courts or tribunals that may acquire jurisdiction. We started our operations in August 2017, and by May 2018, we were fully operational with our first cooperation frameworks and state-of-the-art repository of information and evidence in place. Now, 5 years later, we have been able to conclude 83 cooperation frameworks with UN entities, other international organizations, state, and importantly, civil society actors. The volume of data that we have collected and preserved represent 246 terabytes. It's a large amount. 15 competent jurisdictions have now turned to us already with 264 requests for assistance. And we have already supported 178 of these. The distinct investigation that these requests relate to cover a broad range of international crimes and perpetrator groups. In addition to searching for responsive material in our central repository and sharing these materials with the competent jurisdiction, we're also sharing analytical reports that we are developing as part of our structural investigation. We are preparing geolocation report, expert reports, as well as targeted interview of witnesses. And we have already alerted War Crimes Unit about the presence of suspects on their soil. Our structural investigation currently has three acting lines of inquiries covering detention-related crimes, unlawful attacks, including chemical and conventional attacks, as well as crimes attributed to Daesh. So far, over 30 individuals have been convicted for war crimes, crime against humanity, and even genocide against the Yazidi population in Germany, Sweden, and Netherlands. These convictions concern still low-level perpetrators from non-governmental armed groups, including a large proportion of returning members of Daesh, but also a few former Syrian defectors from the regime security branches. And I'm sure you've heard of landmark decisions that were rendered in 2021 and 22 in the German court of Koblenz, which found that crime against humanity were committed pursuant to a policy to eliminate the rapidly growing peaceful process and to intimidate the Syrian population to prevent future arrests. The court confirmed that killings, arbitrary detention, and torture form part of a widespread and systematic attack by the Syrian state, its security forces, and secret services against the civilian population. These judicial developments are, of course, important, but they are insufficient to combat the scourge of selectivity in international criminal justice, to address the scale and gravity of the Syrian situation, or to decisively deter future crimes, whether in Syria or elsewhere. And this is why the second prong of our mandate, aimed at conducting the preparatory work to support future accountability, more comprehensive accountability before regional, international courts and tribunals is so crucial. Thank you.
Thank you, Catherine, for that overview of the work and mandate of the IIIM. I'd like to turn to Mazen Darwish to share his perspective on this issue, but in doing so, I would also like to acknowledge something that I should have mentioned in my introduction, which is the fact that we're seeing so much innovation in this field, and of course the establishment and work of the IIIM is one example of that, is because victims groups and civil society organizations are themselves becoming so immensely apt at documenting, both at documenting serious human rights violations and atrocity crimes, and amassing immense volumes of evidence that is intended to support accountability proceedings. And oftentimes, as it was the case in the situation in Syria, there is no immediate avenue to put this evidence and information to good use, hence the need to create new institutions. But I would like to turn to you, Mazen, because the work that you've done with your current organization, as well as other affiliations that you have, and your involvement with many civil society groups in Syria has actually been crucial among the work of other organizations, documenting crime scenes and actually spurring the creation of the IIIM. So we'd love to hear more from you on this issue of how do you create pathways for accountability in country situations that are not ICC state parties and where it otherwise looks like accountability prospects are fairly grim.
Yeah, thank you, Elise. Thank you very much, and thank you for the invitation. Honestly, because maybe we are Syrian and we have long history in this type of crime, maybe since 1980s. So we try to learn from our mistake, especially in the massacre happened in Hama and Aleppo in 2080 and 2082. So in my generation, when we grow up, we find there is no documentation, there is no data. We have only a story from here and there, and nothing documented, and there is nothing can be able to share with any jurisdiction, even inside Syria, if there is a possibility. So when the uprising started in 2011, we put this in our consideration. So immediately we create a violation documentation center, part from SCM organization, us and many other also Syrian and another initiative start document this type of crime. And from the day first, we have this hope that we can have a transitional justice platform inside Syria. There is a political transition, we have a lot of hope, and maybe we have also raised all our problem and find solution for the future. But soon after a few years, and especially now after 12 years, we find that it's more complicated and there is no, all of this hope about transitional political transition and transitional justice, it's very far. So we start thinking how we can honestly save our society. For us, me as one of those victims, and the majority of the victims, we work with them. It's not about revenge. It's not about using justice as a tool in the war. It's not a card between a political party against the other. So we need to find a solution for our future, for our children, and also we want to return back to our country. Me, one of those refugee, or even millions of the Syrian. Some of us, the majority maybe, we want to go back. So we start thinking how we can go back if the same authority, if the same perpetrators who made this crime, they are in the power. And for this, the documentation, maybe it's the most important thing we start on it. This is give us more space to advocate for a solution. Even we know that as a lawyer, we are not a member, state member in the ICC or in Rome status. But honestly, the majority of the victim, they don't hear about the ICC. They don't know anything about this international tools or international criminal court, and they want to know why they don't deserve justice, why there is some victim deserve justice and the other don't deserve, why there is some perpetrator or crime deserve punishment and the other can fully have impunity in general. And for them, this is the most important maybe question we faces with the victim. And for this, maybe this type of initiative like the Triple IM give them some hope, some keep them feeling that they should trust the value, trust the human rights, trust all these language here from the international community. But also, for us as a victim, it seemed like there is not enough political will to go ahead in this. Even with the obstacle of the justice and the ICC referral, and as Catherine mentioned, the Russian and Chinese veto. In this regard, we try to push for small steps, go to what we have, the COI, the Triple IM. We, like what happened yesterday in the General Assembly of the UN, the victims themselves pushing for the truth and the faith of the missing people in Syria, even if this will lead to create a new mechanism, special mechanism about this regard. All of these elements, all of this work from the victim themselves, maybe give some hope, maybe tell those victims, those youth, that no need to go to extremism. You should keep the hope, keep the faith of the human rights, on the value of the international community, on this UN body and mechanism. No need to go to extremism, no need to go to violence. There is some hope. And this is what I heard from the Secretary General, Mr. Guterres, yesterday, that the Syrian deserve to have some hope in the future. So this is also about the future in general. How we can use all of these elements when we are not in the ICC. This is also lead to use by example, the International Court of Justice regarding the treaty of the torture. And this is one of the tools. Universal jurisdiction also one of the tools in this regard. But all of these elements, it's just a small steps, just the struggle from the victim themselves to have alternative choices. This is what was done through last 10 years, the documentation, the struggle for small steps, using all the chance and possibility in this regard. In general, maybe start give some hope. But again, this is not the justice in general, what we need and what we are talking in Syria.
Thank you so much, Martin. That was immensely insightful and also, frankly, very moving. I appreciate particularly you highlighting the importance of accountability, not only to redress past wrongs, but to victims' stability to build and reconstruct a future. But I also appreciated you emphasizing how oftentimes in this field, progress is gradual and incremental, as you call it, in small steps. And I think that the work that you've been doing to redress the situation in Syria and bring justice to the victims of atrocities in Syria is a cogent example precisely of that. Let me now turn to you, Liz. We've been speaking about the Syria situation thus far, but this is not the only situation where we have gaps in accountability and we have to try and make incremental progress through small steps. it is one example in which, is one of many examples in which selectivity plays out. So how does selectivity play out, both with respect to other situations that are not state parties to the ICC, but also with respect to the ICC itself?
Thank you so much, and thank you to the organizers and to my fellow panelists. And it's great to see you even virtually, Mazen and Katrine. I'm so glad to be here. This is an incredibly important conversation because, of course, international criminal law exists and is applied within the broader international legal order. And so that means that while it holds out the same hopes for promoting a rules-based system, it's also the object of, and sometimes even the active agent of itself promoting the double standards, the unresolved legacies of colonialism, slavery, and structural racism that are inherent to this broader system. And I say this is an important conversation because I think we have to see it, we have to be alive to it, we have to talk about it if we want to make change. And the issue of selectivity, as a result, has been with this system right from the very beginning. But I think we're living in a moment that makes it particularly ripe to take it out and examine it again, all with the aim of doing exactly what you said and what Mazen was saying about making sure that victims everywhere of serious international crimes have access to justice. That's the reason to have this conversation. And the reason why I think maybe this is a particularly good time is because I do see around us a much more active mainstream discourse around decolonizing international law. And also the ways in which over the past year, the outpouring of support for justice in the context of Ukraine, as welcome as it may be, and it is undoubtedly and unquestionably welcome, has also served to highlight and sharpen the contrast with situations that haven't seen a similar response, whether that's Palestine, whether that's Ethiopia, whether that's abuses by international forces in Iraq and Afghanistan, and so on and so forth. And I really cannot stress enough how live this issue is. I've actually just arrived back in DC from a conversation over 2 days in Addis with the most committed international justice activists you can imagine from MENA and from the Africa region. And our conversation was on double standards, but it is also clearly the question, the issue on people's minds right now. I've been really struck, even in the last 2 weeks since the issuance of the arrest warrant against President Putin, how inescapable this issue of double standards is. On the one hand, you might think seeing an ICC arrest warrant against the sitting head of state of a P5 member is the ultimate, punch back at double standards. But because of the way the situation has unfolded and the disparate attention it's received compared to other situations, I think it's actually serving for many as the sort of most emblematic example of double standards. And that's really problematic and something we have to take very seriously. So there's so many different dimensions of this, but I want to talk about a topic which probably won't seem that interesting, and that is the resources available to International Criminal Court, because actually in the past year, this is the crucible within which this issue of double standards has been perhaps the most obvious and in some ways the most alarming. Some of you here will know that the ICC is funded by its member countries. It's not part of the UN system. Its member countries, currently 123, set the budget every year according to a proposal made by the court. That proposal is examined by experts. States get together at their annual meeting, they adopt a budget, and then the budget is portioned out amongst all 123 countries according to essentially the ability to pay. So that sounds very straightforward, but like any budgeting process, it is absolutely not. And for over a decade now, debate around the court's budget has really been very severely distorted by the insistence of some ICC member countries that increases in the budget, of which there have been, but any increases have to be held down to the absolute bare minimum. And these countries have been primarily European, UK, France, also Canada, Japan. The impact of this, of distorting a genuine conversation about what resources international justice requires, even as the court's workload was growing and growing and growing because of failures in the rest of the international system to either stop abuses or deliver justice nationally, the impact was really predictable. It began to reinforce an ever more selective approach by the ICC Office of the Prosecutor, less so in the opening of overall investigations. We've seen those numbers grow, but more in the pacing of those investigations, the time it takes between starting to move in a situation and getting to specific cases. Also, the very limited number of cases that were brought in any given situation. And perhaps even the clearest expression of this came when the former prosecutor, Fatou Bensouda, concluded that investigation should be opened in Nigeria and in Ukraine in 2020, but said essentially her office had to put a pause for lack of resources. Not the only reason, but clearly a driving consideration was we could open these investigations, we wouldn't have the resources to do them, so we need to reconsider. And I do want to stress that there are not only budgetary issues at stake in the question of selectivity or the court's performance, but resources are not, they are a very real limitation on what the ICC has been able to do. Fast forward to last year, and following the opening of the investigation in Ukraine, the ICC Office of the Prosecutor issued a call for voluntary contributions to support the work of the office. So this is departing from a budget that's set annually and shared in some sense equally among all ICC member countries. The ICC's financial regulations are very clear that voluntary contributions ought to be exceptional, and that's for really good reason. Voluntary contributions, as other tribunals have experienced, is not the road for sustainability, but maybe even more importantly, it's not the best road for independence. To have a budget set on a court-wide basis based on proposals by the court itself is really the best way to make sure that the court can go where it needs to go according to the law and the evidence and its jurisdiction, rather than getting into a situation where there's a sense of pay to play, or the court will do work that is prioritized by big payers and not able to do work that isn't prioritized. States responded really positively to this call for voluntary contributions. And again, in some sense, that's a real affirmation of the role that was seen by many states immediately for the ICC in Ukraine. And again, that's a good affirmation. But unfortunately, even though these contributions were not actually earmarked to the Ukraine investigation, that's not allowed under the ICC's rules, most of them were announced by ministers who had a different agenda. And so they were often announced as if country X was donating $1 million X currency to prosecute war crimes in Ukraine, or even more so to prosecute Russian war crimes. And this has really had a very significant impact on already fragile perceptions of the impartiality of international justice and of the International Criminal Court. And I think what was most significant in terms of double standards and selectivity is that it was some of the same states that had for a decade plus tried to keep the budget down were now those coming forward, and suddenly pocketbooks were open and resources were flowing. And we certainly didn't see that when, for example, the current ICC prosecutor announced that he would deprioritize the investigation of US abuses in Afghanistan, partially, again, for a lack of resources. We didn't see countries saying, no, hold on, what's your Venmo address, Mr. Prosecutor, we're glad to send you money. And the geography here matters because some of the court's biggest payers are European countries. And so the sense that they were willing to do this for Ukraine, again, just doubled down on some of the very difficult double standards we see in international justice. The story's not over. States did have an opportunity to correct this by providing the court with a bigger budget in this past regular cycle. That didn't happen for a lot of different reasons, but certainly the issue of voluntary contributions played into it, and certainly the issue of alienating some of the other regional groupings among the ICC member countries played into it. So I think the way forward is to continue to call out what this is. It's not just bad budgetary policy. It really is double standards manifested, and get to a point where we can return to a more genuine conversation about what an investment in the ICC really would look like.
Thank you, Liz. I think you brought a very important perspective on an issue that is not often discussed, as frankly, which is that of resources and capacity to deliver justice, but also how political will, agendas, and narratives can, alongside the issue of resources and capacities, can affect both the realities and perceptions around double standards and selectivity in international justice. I think this is the perfect segue to actually now turn to Sam to add his perspective on the issue.
Thanks. Thanks very much for the invitation. It's great to be back here live and back in the U.S. and see a lot of friends and colleagues, and especially on this panel where it sits at the intersection of law and human rights and justice, actually things that we don't always talk about, but given especially the work that Mazen has done and that Catherine has been pursuing in the context of Syria, it's become really live. And I think notwithstanding all of the problems, it is important for me to acknowledge how far we have moved in terms of the question of international justice and demanding the rights of victims. We've gone, with the establishment of the ICC, I think a major step was taken, notwithstanding all of the problems. And what we've seen is, given the problems of the ICC, some of which Liz has just mentioned, and I'll come back and talk about, but given those problems, the political blocks, the resource issues of the ICC, we've seen victims seek new methods, new platforms for demanding their rights. Actually, I use the word victims, but they're rights holders. I mean, all people under international law have the right to accountability and truth and justice and remediation and non-recurrence. This is a right. And people whose rights have been violated and others have been demanding those rights be observed. And therefore, we've seen a real proliferation of demand for accountability and fascinatingly, for individual criminal liability. Again, it's astonishing for me how quickly we've gone since World War II from the idea of kind of absolute sovereignty. When I started work in the human rights field, the idea of individual liability seemed absolutely impossible to fathom. And now we've moved so fast that rights holders are saying, well, the ICC can't hold up with it. You know, what has the ICC ever done for us? Let's just throw away this whole thing. It's garbage. And therefore, they've looked for other. So we are now up to around 16 different mechanisms, international mechanisms, that are pursuing evidence that will potentially feed towards the process of criminal liability. That's astonishing. Most of them are just in the last 6 years. So most recently, we have a commission of inquiry on Iran, created by the UN Human Rights Council, which has the mandate to gather evidence. It's different from documentation. The idea is that they're going to gather evidence with a chain of evidence that could potentially be provided to people like Catherine, perhaps, who would then be able to use it in some forum. The new UN Special Rapporteur on Afghanistan, a post that has had a lot of precedence in the UN system, also has the mandate to gather evidence. This is a huge step. This is completely different from other special rapporteurs that we've seen. It is at once a reflection of the frustrations with the ICC, where it's politically blocked or doesn't have the resources, but also developments in international law. And I think it's been really, really interesting and positive to see that states have now effectively signed on to this. And we see that through a proliferation of the different mechanisms that we've seen. It's crucial because if we listen to what Mazen was saying about the absolute impunity in Syria that Catherine has been working to try to remedy, there is a direct link between Russian behavior in Syria and Russian behavior in Ukraine. As a prosecutor, you could clearly look at that. It's the same strategies, it's the same units, but there's also a clear link to what happened in Chechnya. And so for those of you who are interested in political science, from my side, this is a riposte to the question of, justice is useless, international rights are useless. For years, people cried about what Russia was doing in Syria. There was no accountability for it, and now we're surprised that Russia is doing the same thing over and again. And I think it would argue that perhaps breaking the cycle of impunity and providing accountability is one way of trying to curb this. Not to forget that there is also a direct link to the impunity that the U.S. enjoyed for what it did, aggression in Iraq, for the occupation, for what Israel has done for its occupation of Palestinian lands. This notion that there must be accountability is now quite important. The rights holders are demanding it, and we see the international system responding to it through a proliferation of different mechanisms. That's the positive. The negative is that we have a proliferation of different mechanisms that are at times incoherent, that have different mandates, different ways of working, and are hampered by lack of resources, financial, but very often simply by UN bureaucracy. It takes years, it takes months to staff these resources. They don't know what IT system they're going to use. They don't know which email system they're going to use. They're there for a year or two, and then the political winds change, and it ends. So we've seen this happen, for instance, with the Commission of Experts on Yemen, which the Saudis simply managed to kill at the Human Rights Council. The Libya fact-finding mission is nearly at its end. The Ethiopia Commission of Inquiry is about to be killed by the Ethiopians. So again, we've seen successes, but we see real problems in terms of what we really want. The demand of the rights holders is very real. It has had some traction in terms of political will, in terms of international responses to it, but it's quite important to be aware that we don't get into a trap of now shattering the expectations of the rights holders and the victims. They want to know why the ICC prosecutor moved forward with the arrest warrant against President Putin. I think they all agree that that's a good thing, but could not move forward with arrest warrants or even with an investigation of Afghanistan on the pretense that the investigation would not really have concrete results. It was, by the way, the same body that ruled on that. So these are real questions. Now, one way to answer that, and I think I'll be able, maybe I hope to talk about it a little bit further, is the possibility to make a more coherent response come out of all of this. And this is something that has grown organically out of discussions with the people who are involved in this at the intersection of international criminal law and international human rights law. And it's the idea to create a standing mechanism, something that is there that the UN system can work with that does a couple of different things. One is it can be available to move quickly and coherently to respond to demands for accountability. You can think of all of the systems that I've talked about, all of the mechanisms that I've talked about as prosecutors without a court. They're there when the ICC really hasn't been able to work, right? So that's why we need a commission of inquiry on Syria, because the ICC is blocked. So we have a commission of inquiry that then feeds into universal jurisdiction cases. The idea here would be that we would create a standing mechanism that would build on the experience of mechanisms like the investigative mechanism on Syria, like the mechanism on Myanmar, to be available immediately to start gathering evidence, as a prosecutor or as an investigator would, even where the court and the tribunal is not immediately clear. The second advantage is that it would be able to significantly improve the quality of the evidence that is gathered, the speed of the evidence that is gathered, the availability of the evidence that is gathered, so that if we are pursuing lines of justice through universal jurisdiction, for instance, prosecutors in Germany or Belgium or the US, or I hope increasingly in Argentina and Turkey and Australia, will have one place to go to be able to get this information. And this proposal for a standing mechanism, something that my previous employer at the International Commission of Jurists was very lucky to be able to work with Federica at Oxford Ambassador Rapp, who is there, I think, right there, with their work on Oxford to come up with this proposal, and it has gotten some traction. I can go into the details a bit more, but I want to end by saying that it is, to me, an organic outgrowth of the demand of rights holders and victims for accountability. It is part of their demand for transitional justice, which is not just about individual criminal liability, but truth-telling and remediation and deterrence and non-recurrence. And it doesn't address all of the problems, but it begins to address some of the issues around selectivity and hypocrisy and double standards. It won't answer everything, but creating something that is standing will at least allow us to focus the debates away from the political questions around establishment of mechanisms into how those mechanisms operate. And I think it's a really important moment because this issue has traction. I think we are moving forward on it, and I'm all for it. I think it's time for it. I can go into the details, but yeah.
Well, I'm also on the record being all for it, and I hope we can discuss the proposal a bit more, and thank you for bringing it to the discussion. I'm conscious of the fact that there are additional points that the panelists wanted to raise, but also that we have about 12 minutes to the end of the panel, so I wanted to take this opportunity to see if anyone in the audience had a question at this time or wanted to interject. Okay, yes, please, if you can approach the microphone and introduce yourself.
Hi, how are you? My name is Andrea Moseres. I'm a student at NYU and a transitional justice scholar, so I might give you the opportunity to maybe discuss these different mechanisms that you were addressing. So my question is, due to the fact that the ICC is dealing with immense challenges that you just mentioned, I think is how to manage victims' expectations. I come from Colombia, and I know managing victims' expectations in terms of justice is very, very difficult because we can't really opt for absolute justice. I mean, absolute justice and absolute prosecution is very, very difficult. So my question is, should we turn to different mechanisms of accountability, as you were saying? And if we do, how do we also sort of balance the fact that some victims are not pursuing prosecution as international justice, but are leaning towards a more ample understanding of justice, truth commissions, and, well, peace process negotiations and transitional justice? Thank you.
Thank you. What an excellent question. Okay, why don't we take your comment, Ambassador Rapp, and then I would actually like to ask all panelists to answer that question because I think it touches on some of the points that each one of you wanted to address in the second round. But yes, please, Ambassador Rapp.
Yeah, it relates to what Sam said about these mandates that are ending. Yemen, a couple years ago, the Libya Commission goes out of business tomorrow and the Libya violence doesn't end. And of course, Eritrea, where we have in Ethiopia, where the University of Ghent tells us that there are 375,000 dead in the last 2 years, and who in the world knows about it. And obviously, if there's going to be transitional justice, they need evidence, they need the work to build the cases. What could, to put it to Sam, what could a mechanism do for these kinds of situations as these sort of fact-finding missions end their mandate? And more really a question for Mazen. What does he recommend for the victims and survivors in these countries that no longer have these mechanisms to turn to in terms of what they can do to build the evidence and build the contacts that may open the doors to justice somewhere, somehow?
Thank you so much for that poignant question. Can we start with you, Catherine, and then turn to Mazen, and we'll just go with the order that we followed earlier.
Sure. How to manage victims' expectation? I would say it's not as difficult as it sounds. Being engaging with victims and survivors, identifying the right association that represent different communities of victims and survivors, because in a context like Syria, but it's the same in many other situations, there are many different victim communities, and you can just engage with a couple of victim survivors and think you have a full engagement. But being honest about the efforts that are being made, stop considering that unless they come forward as witnesses or civil parties in cases, victim survivors have no agency. They can be consulted. They can bring a lot of perspective about their needs, the barriers that they face in accessing justice, and if only sharing with them the steps that are being taken, making them see the progresses, the difficulties as well, being honest about prospects, listen to their perspective about engaging in support of new emerging opportunities of justice. This is exactly what we're trying to do at the IIIM, and I think it's not so difficult. I don't think we face communities of victim survivors that are unrealistic about the prospect, about the difficulties and the challenges, but the mere fact of accepting that there are important stakeholders, right bearers, as was said before by Sam and Lise, is really an incredibly important first way of engaging with them. And I would say we wouldn't be able to do the work we do at the IIIM without their with that kind of engagement. We even went from an early engagement with documenters, of course, with a mandate like ours, which requires us to put together and analyze material already collected. This is the first community you turn to, CSOs documenting or CSOs advocating for justice, but we quickly saw the interest of also engaging directly with victim survivors representatives because they have a different perspective on justice and on accountability. And I think then there are other ways that can be made to support a victim survivor-centered approach, which we've engaged in, adopting dedicated strategies to make sure that you're going to be able to surface the experiences of those which are less visible, including women, including boys and girls. That takes dedicated effort. And certainly as well understanding, as if I understood correctly the question, justice is not just criminal justice. It's not just judicial justice, identifying ways you can support the search for missing person. That's clearly at the core of the demands of Syrian victims and survivors. And there are many, many good ways of doing that in an accountability mechanism like ours. I'll stop there because I'm sure my colleagues on the panel will have many other perspectives to offer.
Thank you so much, Catherine. And Mazen, would you like to go next?
Yeah, thank you, Frederica and Catherine. Just I want to thanks also Sam. Just I want to mention that I went to Ukraine, to Bordonika and Sumy and many other of these places, and I hear it from the Ukrainian victim. This is because we allow Putin to destroy Aleppo and do this in the Syrian, and we don't do anything. So yeah, it's very connected. And thank you for the question. I totally agree with Catherine, except that I don't think that it's easy to manage the expectation, especially in the beginning with the first maybe UG trial and victim think that this will bring the justice for the whole Syria. While we know that these cases, it's very important, but this is not the justice. This is to keep the file on the table, to not allow to the regime or to the lord of the war to go to any political agreement, ignoring the victim rights. So we need to be honest, direct, clear with the victim. Tell them everything as it is without give them false hope in the general. I think this is the most important. And to deal with them as a stakeholder, not as a miserable victim. I still remember when I was released from the prison and came to Europe, and many, maybe in good way, many organizations, international organizations, want to show the community, the victim. So it seemed like, come and see the victim in the positive way, in the good willing. But in the end, for me, I think that I'm like monkey in the cage and asking the people to coming and to look to me. So to deal with the victim as a stakeholders, They are a partner in the justice. They are deserve to know everything in good way, in a clear way, to respect their suffering, but also to know that they are part from the justice and accountability. We need to reach their satisfied. There is no absolute justice. I don't know what the justice for the mother who lost her children, but we need to reach their respect and satisfied. And the process itself, it's very important, not only the verdict, the whole process. For this, I think this is the very good things coming from the IIIM, that they dealing with respect with the victim and with the civil society. And this is why maybe the majority of the Syrian civil society engagement with the IIIM. Ambassador Stephen, thank you for your question. I think the most important, the documentation. Some of this documentation, we do it in 2013, by example, when the chemical weapons happened in Al-Ghouta. After 8 years, we use it. So documentation is very important. Professionality of the civil society is very important, and also to organize the victim themselves. To be honest with you, the NGO, for financial reason, for political reason, could be stopped. Individual human rights defender could be died, could be killed, could be changed their mind. So the guarantee of the victim rights, the victim themselves. So we need to organize the victim, to give them the leadership of advocate for their need for justice and accountability. And this is how we can guarantee that even after 10, 20, 30 years, and this is maybe what happened in Argentina and in many other countries, after 20, 30 years, the hope keep living because there is a good documentation and the victims are organized. Thank you.
Thank you, Martin. And Liz, would you like to go next?
I think it's a really important question, and I think there's a very close connection between the question of centering victims, meeting victims' expectations, and the issues of selectivity. Because selectivity or double standards, it's not monolithic. I think you'll find them anywhere there's a power dynamic in the system. So it could be anywhere from a double standard at the P5 in the Security Council, right down to a particular government deciding to weaponize justice to go after its adversaries. And so I think by centering victims and supporting victims, I think actually that might be one of the maybe most obvious but also most important ways to try to erode selectivity and erode double standards. If victims and victims associations are empowered to have the agency to push forward their justice goals, then we would have a diversity of voices and a multiplicity of justice goals, which doesn't make life easy because we're already dealing with a system that doesn't have sufficient capacity, but it would help to continue to get all of these voices and all of these perspectives on the table so that we can make sure as a system we are not falling prey to double standards because we're not hearing from people how the system is affecting them and how they're perceiving the system is operating. And to do that requires a lot of different things. It requires, as Mazen said, it requires support to civil society. It requires funders to stay the course in providing financial support to civil society and in also working to combat efforts to shrink civil society space and to go after human rights defenders. And it also requires what Katrine mentioned, which is the willingness of these institutions to actually engage with victims and hear what they're saying and also be willing to change. So not only to inform victims about what they're doing, but to hear and have it be a genuine two-way dialogue and be willing to adapt. And we have seen, I'd say, at the International Criminal Court, really uneven experiences when it comes to that. I think sometimes there's a fear to find out what victims think because there's a fear that you won't be able to meet those expectations. And that's very hard to hear. I can completely understand that. But I think, as Katrine and Mazen have both said, I think if you actually provide opportunities to consult and to engage, it's a conversation, it's a dialogue. It's not something to be afraid of. It's actually an essential component of doing your job well. And then the last thought I had on this one is, I think this is where, and because this is the American Society of International Law, I wanted to make a bit of a plea to scholars out there. There is a lot, and I'm sort of new to exploring this myself, but there's been a lot that's been written about decolonizing international law generally. I think there's been less, at least less that I've been able to find, on decolonizing international criminal law in particular. And the reason why I think exploring that could be very interesting is because I think that could be a process of understanding that colonization and the international legal order was in part a process of dismantling other systems, other ways of being, other ways of knowledge. And if we can start to decolonize that and claim back those other ways of being, we might be able to see where some of the gaps and some of the silences are currently in international criminal law and use it as a tool to come closer to meeting victims' needs.
Thank you so much, Liz and Sam.
Thanks. Well, I agree with everything that has been said before me, so I want to incorporate that by reference. The question around, if I may given a flight of academic fancy, the situation with international criminal law is really fascinating because it's not a parallel and an analog of the national prosecutorial system, which is usually an expression of the sovereign's power. And most of international human rights law and civil liberties and the U.S. Constitution is effectively designed to stop the sovereign from using that prosecutorial power. The international criminal legal developments that have been seen have been driven from the bottom up. They are demands of the victim, and they're in fact usually, even going back to Nuremberg, a signal from the states, the powerful, that they've really, really messed up, and that something has to be done to respond to the demands of the rights holders. So it comes from a different place, and I think people forget that. The initial round of responses to international criminal law were largely populated by people who came out of the national criminal law system, who have a completely different historical context than the international human rights law system. And we really, really saw problems with that. They didn't trust victims groups. They didn't want CSOs to do any documentation. They didn't really write victims that much. They just wanted to prosecute bad guys. And that really did not work really well. And I think we have seen huge steps forward in that. I think what Catherine has mentioned, the experience of the IIIM is really, really important. It's something that I see that the Myanmar mechanism has tried to learn, and I think there's really a lot to learn from that. I would have to say the ICC was pretty bad in the early days in terms of the colonizing approach that it had and not being victim-centered, and it's moved forward. That's crucial because I think, as I said, if I can just go back to the idea of a standing mechanism, the lessons learned and the best practices that have now been established by Catherine and the IIIM, by other of these mechanisms, really need to be taken on board, need to be systematized, and need to be made available to future mechanisms. And again, that's another reason why a standing mechanism, I think, is really, really important. I can't emphasize enough also these issues of establishing ways of working with CSOs, establishing ways of working with rights holders and victims, that right now, each time a new mechanism is created, they have to learn that all over again. They have to hire the people all over again, and then within 3 years, they have to let those people go. That's a huge waste of resources. Where this, to me, is really significant goes to the issue of transitional justice in places like Colombia. I think what's been done in Colombia really requires a lot more study. In many ways, I think it's probably the most advanced national approach to transitional justice that we've seen in many places. Criminal liability and individual justice are hugely important. And when you ask victims and rights holders, they will demand that. But they also want to know the truth. And in some cases, they want remedies. They want the school that was destroyed to be rebuilt. They want the clinic that was destroyed to be rebuilt. And that should be also part of the process and part of the discussion. And that's why we have to make sure that at this moment, when the discussions around accountability have really, really moved forward, The pendulum has swung from purely being state responsibility and no criminal individual responsibility now to all of the discussions, certainly within the UN system, being around individual responsibility. That's what they want. But that's not all that is necessary. It's not even most of what is necessary. So again, we need to bring this back a little bit to understand that what we want from justice is more than just individual criminal liability, although that's a huge part of it. And I think we can learn those lessons from the mechanisms we have now and try to bring them together in one existing mechanism that can support this momentum. Thank you.
Thank you, Sam, and actually thanks to all of the panelists for underscoring this notion that victims never were and never should be considered as passive recipients of administered justice, but they're actually the main justice stakeholders. And in fact, as we opened the discussion by saying, they're the moving force within what we might refer to as an evolving ecosystem, inside which both institutional pathways, but of course resources and capacities have to be provided if justice is to be delivered. Selectivity and double standards, of course, remain as persistent challenges in the international justice project, but I think my key takeaway from today's conversation is that the best strategy to try and overcome these challenges is to recenter the conversation around the needs and demands of victims. This is one of the most important ways to ensure as well a future development for this field that is coherent and more even in the ways in which justice is delivered to the victims of atrocities in all situations, not just some. Unfortunately, this is all the time that we have today, so we're going to have to end here, but I would like to thank our panelists, all of you in the audience, and if you can please join me in a round of applause.